This year, there have been $2,340,780,094 spent on undeserving people who were paid out by homeowners who had an unfortunate person get injured on their land, and the state decided that somehow it was the homeowner's fault. This happens far too often, and the idea that just because you receive an injury on someone's property, it's ludicrous to suggest that it is the homeowner's fault and that you are entitled to compensation. This is a significant area of positive change for the American homeowner and can lead to numerous changes that promote safety and reduce stress on a homeowner's wallet. There are many reasons why personal injury laws should be capped. Huge amounts of money are spent every year on them. Heavy fraud is sown into the industry that the lawyers and the victims exploit. There have been many cases of burglars breaking into homes to then sue the homeowners for the burglar getting injured there. It is illegal to not let people on your property know about the potential dangers that reside there. In many states, the castle doctrine doesn't extend when a person doesn't occupy the home at the time of the break-in, which many people believe it should. There should be a max claim implemented that is 1/5 that it is right now. One common misconception about the law is that if someone breaks into your house and they get hurt, that's on them. It's a little bit more complicated than just that. A trespasser must be proven to be on your property without your knowledge or permission to deem yourself less liable. Admin. This part of the law certainly complicates things, and coupled with under premises liability laws, a property owner must warn their guests of hazards on the premises. Brockman. These guests include trespassers, and signs warning of possible dangers are almost always required. So even if a trespasser breaks in and then drowns in the pool, the homeowner is still responsible and can face charges brought by the trespasser's family. The average homeowner policy is about $1,500 a month in Arizona. It doesn't sound like a lot, but that's $18,000 a year that could be significantly brought down with a few tweaks to the law. Many people do not realize what their insurance policy provides protection for until they need their policy and find out about the many exclusions used by insurance companies to deny coverage, MOS. This is extremely troubling given the fact that they are already overpriced and that many firms out there are using the law to screw over clients. Another concerning issue is that some firms will go to great lengths to squeeze any amount of money as they can out of people. The defendants invited the plaintiff and her husband to a backyard barbecue. While there, the couple double jumped on the defendant's 14-foot diameter trampoline. The plaintiff was injured, suffering serious injuries to her right knee. Bandana. The jury in this case awarded the couple the win, which the judge came out later on record and said judgment was inappropriate because a reasonable jury could find that defendants knew or should have known that their trampoline posed an unreasonable risk of danger to plaintiff, Bandana, which goes to show how wild some of these cases really are. Lawyers are part of the problem, doing shady stuff and craft laws and policies so that new policies offer very little protection for consumers, MOS. Because this is happening, policyholders are continuing to lose more rights under their insurance policies, MOS. This has been a downward trend in the last couple of years, and it's getting worse in many states. The policies are getting more expensive because the liability charges are also increasing, and all for no good reason. According to experts, the best way to combat this is to decrease the amount of money one can sue for in a personal injury case. This would bring down insurance costs for those who buy insurance and decrease the bill for someone if they don't personally have insurance. The law is in no way perfect, but some argue that personal injury laws need to have a higher maximum in case someone gets injured and they can't afford the health care caused by that injury. Many disagree, though, and say that while there may be exceptions, hospital bills that pertain to these types of injuries are usually less than what the court charges the defendant with. That, coupled with even if a person trespasses on your property and has no permission to be there, you are still at risk of being sued, admin, and you can make a personal injury claim regardless of negligence or wrongdoing, Bieber. The majority of personal injury claims are bogus and are just people trying to abuse the current system. If there was a more definitive screening process to create a case, or the overall amount that can be taken is decreased, this would surely remove or at least soften the problem immensely. The law says the defendant should be held accountable regardless of whether they did something wrong or not. Bieber. This is another grand issue that needs to be dealt with. The current law works in favor of two lawyers fighting it out instead of two people reasoning whether funds should be awarded. The whole point of having a lawyer is to help you to review the law to determine all parties who may be legally liable for compensating you. Bieber. This is a problem because the lawyers are taking advantage of the system to fill their pockets and to try to squeeze all the money as they can from people who didn't do anything wrong. The current state of personal injury law places an unfair and overwhelming burden on the homeowners, encouraging exploitation by opportunistic individuals and their lawyers, reducing maximum claim amounts, reforming liability laws, and limiting legal loopholes would protect homeowners while still ensuring justice for legitimate cases. To create a fairer, more balanced legal system, action must be taken to curb these abuses and put homeowners' rights back where they belong, the forefront of the law.